Good afternoon, and welcome to Payentry's weekly webinar. Actually, we're having two webinars this week. We have this one today, and tomorrow we have one on employee files and file retention. So if you haven't registered for that, make sure you do. So today we're going to be talking about the Department of Labor audits and how you can prepare for those. I'm Kathy Graham. I'm head of the HR services area at Payentry. And I'm here. Anytime you have a question you need to ask, please call me or shoot me an email. You do have a copy of this presentation in PDF format in your the box as a handout. And we will also be sending you a copy of the recording as a registrant in this event. Let me first of all throw this slide up. Our webinars are intended for educational purposes only. I'm not an attorney, so the information that I provide during this presentation and the Q&A session that we have at the end should not be construed as legal advice. So let's get started. This, like all of my other webinars, will be short and sweet, just giving you the facts. The Department of Labor is at your door. Are you ready for an audit? The DOL oversees the Fair Labor Standards Act compliance, and underneath that is included, or things that are included under that are minimum wage, overtime, record keeping, which we're going to talk about tomorrow, and child labor laws. The Department of Labor also monitors and oversees FMLA compliance. So if you do have more than 50 employees, if you do have more than the number of employees, I think it's 50 within a 75-mile radius. Don't quote me on that. My brain is fried right now. But anyway, the Department of Labor monitors that and can do audits on any of these things if they come into your facility. The most common reason for audits is that somebody complained. It probably is somebody that you terminated and they're upset and they're going to find a way to get back at you. It could be an employee that's still working for you because you cannot retaliate against someone who files a complaint against you. The Department of Labor will never tell you who complained. That's not part of what they do. It is a confidential complaint, so you will never know. You could probably suspect, but you may not know. That's the most common reason for audits, but the Department of Labor is known for its industry-specific audits. And by that, I mean they can be random across an industry, or it could be they focus on companies that have low wage earners, including restaurants, construction workers, retail, and there are many others, farm workers. I'm sure that you can think of a ton of industries that use low wage earners, minimum wage staff. So let's take a look at some examples of recent penalties. I mean, I have been researching this for a while over the years, and you rarely see anything under 5 figures. But one that I came up with was a recent one. A Tennessee Little Caesars franchise violated child labor laws and was fined $161,000. There were, I think this was in Pennsylvania, 3 Japanese steakhouses were charged $1.45 million. They only have 116 employees, but the penalties were much higher because these restaurants, as a group, continue to violate the rules that they keep getting fined on. So with a $1.45 million fine, they may be out of business now, but because the violations were willful and repetitive, the penalty goes up. And then another one, there was a home healthcare staffing company that had 43 employees misclassified as independent contractors when they should have been employees. Big, big audit point for the Department of Labor right now. And they were fined $430,000. $430,000, yes, $430,000. So almost $500,000. So how does the Department of Labor notify you if they're going to audit you? Well, you get very little or no notice. You can get a letter or they can give you a phone call and let you know that they're coming. You can ask for time to prepare, but I doubt you'll get very little time. So, because they move pretty quickly. And what does an investigation look like? So, after they call or send you a letter and tell you when they're coming, you'll have an initial conference on your premises. The auditor that's going to be doing the investigation will be part of that conference. And anyone that you want to include in the conference would be there also. Here is where they will request and examine your records. What they ask for will depend on the nature of the complaint. So if they're looking for a wage and hour complaint, they're going to look at your payroll records first, but it does depend. If it's a minimum wage employee classification, if it's an overtime issue, or if it's an FMLA leave issue, because they could be investigating more than one thing at a time, they may ask for other documents. Definitely, they're going to look at your payroll records. And bottom line, they have access to everything. So you cannot refuse to give them something. Now, they're probably not going to ask for medical records, but they do have access to anything that is in your files. Another thing they can do is they can conduct private interviews with your employees. That can be current employees or past employees. And after they've done all of that, they will come to a conclusion regarding whether or not you have violated the laws. And it is their decision. One of the things that I will tell you, I have been on the other side of an audit before. One thing you definitely want to do, and it's recommended by most, like the SHRM Association, is that you be nice to the auditor. That person holds your company in its hands and your financial side of it. And if you're nice to them and you treat them nice, bring them a cup of coffee, put them in a nice quiet place, treat them like a human being, um, there's a chance that you'll get off better than if you were mean to them. And that sounds really ridiculous, but it's true. So that's just kind of an off the side note to always be nice to the auditor, because if you're not, they won't be nice to you either. So following the conference, you are going to be informed of any violations and how to correct them. That will include, if you have violations, back pay, and this is back pay to current, depending on the situation and the scope of this. It could be back pay and penalties to people who don't work for you anymore, who haven't worked for you for a while, because they can go back 2 years. There is a 2-year statute of limitation unless your violation is perceived as willful. If you willfully disregarded state or federal law, there is a 3-year statute of limitations, and that willfulness is determined by whoever is auditing. Willful or repeated violations, if you've been through an audit before and there was something that you were charged with before that you didn't fix, you're subject to civil monetary penalties up to $1,000 per violation. I'm going to go back up to the back pay and penalties. This back pay goes all the way back for 2 years. It would also require a number of other things. If the Department of Labor is involved, it could mean that you have to make additional contributions to the retirement plan because the person was underpaid and could not put in money to their retirement plan. I mean, there are all kinds of little caveats that it can take veer off into different directions. So it's a very, it can be very expensive. And on top of that, there are penalties and interest for the money that you owe the individuals. That goes directly to the employees that were violated. If you violate a child labor law, those violations carry up to a $10,000 per violation penalty. And if you have willful violations in any of this, there can be criminal prosecution. So individuals can be held accountable for this. As a human resources person or someone who might be in charge of the payroll or making rules, you would want to be very careful that you're complying with all of the state and federal laws concerning employee payment and leaves. And when we're talking about this, I'm primarily talking about federal laws because the Department of Labor only cares about federal. The One of the things that I will say is that there are lots of state laws now that have leaves of absence and special taxes for different things. And so you need to make sure that you're correct with those because if the state finds out that the DOL has audited you, then they will follow suit, as probably will the IRS because all of these agencies share information. Um, there are going to be back taxes that are due on the back pay. There are going to be, for example, if it's a misclassification of an employee as an independent contractor, then you're also faced with doing things like, because that person should have been an employee, you're going to have to go back and put them on your health plan for, um, for the 2 years prior. And insurance companies are not prone to allowing you to go back 2 years to put someone on your health insurance. I think you probably have figured that out by now because of how restrictive they are. You have to do it within a certain time frame. So what that ends up meaning is that you're going to end up paying any health claims that they had over that period of time. That also goes to life insurance, et cetera, because you've denied an independent contractor the benefits of an employee. So it's going to be more than a pay issue. It's going to be concerning employee benefits. And then the IRS gets involved. And today we're only talking about the Department of Labor, but the IRS, in the case of an employee misclassification, independent contractor versus employee, they will be in assessing back taxes and penalties. So you do not want the Department of Labor auditing you. Obviously, you don't want the IRS auditing you, but let's just say you get audited by your unemployment firm that does your unemployment. There's a chance that that could trickle into another state department agency if you're state run. So there's just a lot of fingers in all of this, a lot of hands in the pot. So what can you do to ensure that you're compliant? Well, you need to be proactive. You need to do a self audit to ensure that what you're doing is compliant with all state and federal laws. Review all of your job descriptions. That's how you decide whether someone is exempt or non-exempt, whether they're an employee or not an employee. So if you don't have job descriptions, this is one of the first things that the Department of Labor is going to ask for are the job descriptions for certain positions to determine whether or not they're exempt or non-exempt. That is salary or hourly. Then you need to make sure you have a full understanding of both state and federal wage and hour laws. On top of that, Ensure your employees are classified correctly. Are they exempt or should they be non-exempt? Are they independent contractors when they should be employees? Make sure everyone is classified correctly. This third bullet is the focus of a lot of investigations nowadays because it's easy prey. And this is where the IRS and the Department of Labor make some extra money and pay for the extra auditors that they've hired. Make sure you keep accurate payroll records. And I say that and everybody says, oh, sure, we keep accurate payroll records. Well, if you keep everything in Payentry, you're fine. But that Japanese chain of Japanese restaurants did not keep good payroll records. And they continued to do that over a period of time. And that's why their violations were classified as willful. And when I say accurate payroll records, that means making sure that no one's working off the clock, that you're paying everybody for every minute they worked or the time that they worked, so that you don't have a timekeeping issue. Always apply your policies consistently. I think that in human resources, that's one of the terms that we use most often is consistency. Always treat everyone the same way. Make sure all of your records are complete, and that even goes down to your I-9s. Have you filled out the employer's part of your I-9 section? And once you've done that, address your areas of concern. It's a big process, but it is something that you need to do to make sure that if somebody knocked on your door or called and said, we're coming by tomorrow to do an audit, that you would be ready for that. And it takes a lot of time. So what I'm going to offer here is I'm going to tell you a little bit about what our HR services team can do to help you maintain your compliance and avoid those penalties. So how do we help? Well, first of all, you have unlimited phone and email access to an HR expert. When you have our payroll package, you do have limited access to the HR staff here. And that means you can call and ask a question. You can call and we'll give you a form or a template. But it's not very time consuming on our part. It doesn't require any research, but you do have that option. And we do have a lot of clients that just call and say, I have a quick question I want to ask, and can you help me with that? And the answer is yes. So with that unlimited access comes assistance with employee relations issues. You don't know whether you should fire this person. You fired this person or the supervisor fired them and you don't know if they should have, that kind of thing. We give you advice on new policies and procedures and help you write them. We provide you with updates on new laws as soon as the new law is available. We make sure that you're aware of it. And then what we do is we come in and we do a comprehensive HR audit. We look at your compliance with various state and federal laws. We look at your employment records to make sure that you're keeping things the way that you're supposed to. We look at how you've classified your staff or your employees. We create a handbook for you and we review it annually. It would be compliant with any states that you're in. We have some companies that are in 20 plus states, so it can be a big job on our end. And then we'll review your state and federal compliance, including COVID-19, what there is left of it. We'll also help you audit your I-9 forms. In addition to all of that, you get a subscription to a learning management system. So you have access to training for your supervisors and your employees. This does include harassment training, and it is state specific. If you're in a state that requires it, it is custom to that state. If you have remote workers, we provide an e-poster subscription for each of them so that they can view the same posters that people who work in your office can, which is a Department of Labor requirement. And then you get a discount on any project HR work that comes up. Normally, most of it's covered under the compliance package, but if you wanted us to help you with, you know, an entire compensation plan or an entire performance management system, then there might be a little bit of a fee on that. But for the most part, we become your HR team and help you make sure that you're compliant. Bottom line, you get peace of mind. So what does it cost? It costs $8 per employee per month. There's a one-time setup fee for a lot of the work that we do up front of $350. There's a $200 monthly minimum, and that is for employers that have less than 25 employees. It's not 200 plus $8. If you have 25 or less, it's just $200 a month. And there is a 12-month contract. So, knowing everything that you need to do to become compliant, if you want more information on this, please shoot me an email or reach out to HR services at payentry.com. We would love to answer your questions. And also now, if you have any questions from the subject matter of this webinar, you could type it into the question box and we can answer that right now, or you can email after the session is over. But does anybody have any questions? You can type them into the question block. It doesn't look like it. So please just shoot us an email. Let us know if we can help in any way. We are here regardless of whether you're an HR services client. Give us a call if you have a question. We appreciate your being here today and hope you have a great rest of your day.